case briefs, and so much more. LSData's got what you're looking for.
In a 2002 case involving the New Jersey Superior Court, the dispute centered on whether a warranty promise for repairs made during a warranty period could be considered a promise of future performance. The plaintiff in the case, Poli v. Daimlerchrysler Corp., purchased a new 1992 Dodge Spirit from the defendant with a 7-year, 70,000-mile powertrain warranty. The plaintiff encountered a series of issues with the engine timing belt and claimed that the warranty was breached when the defendant failed to repair it properly, causing further problems with the car's operation. The defendant argued that the plaintiff's claims were time-barred, as they had not been filed within the 4-year limitation period established by the Uniform Commercial Code. The court had to determine if the warranty was a warranty of future performance or an independent promise to repair defects. It was concluded that a cause of action does not accrue until the seller fails to perform the required repair within a reasonable period of time. The court determined that the powertrain warranty was a warranty of future performance, allowing the plaintiff's claim to proceed. However, the repair warranty did not ensure future performance, rendering the plaintiff's claim time-barred. The court also applied NJSA 12A2, 725 to the plaintiff's Magnuson-Moss Act claim, which was not time-barred.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.